So let's talk about the cost of making mistakes on your green card application or any immigration application in 2025. Hi, my name is Ebony. I'm an immigration attorney. I am located in Jersey City. However, I represent clients in all 50 states and around the world when it comes to U.S. immigration. And I wanted to talk about the cost of making mistakes. And the reason why I want to talk about this is because I meet so many people who have come to me after they have applied for immigration benefits on their own and made a mistake on their application. Now, in the past, what would happen typically is if you apply for immigration benefits, and let's say you made a mistake on your application, right? For example, you submitted the wrong application or an expired application. In situations like that, USCIS would typically reject your application and send it back to you. They wouldn't accept your fee, they would just reject the application altogether. Or let's say, for example, you submitted your application and you didn't submit supporting evidence that was required for the form. In the past, typically, USCIS would issue you an RFE, which stands for a request for evidence. So they would be requesting additional evidence in order for them to adjudicate, make a decision on your application, right? So this evidence that's missing is what they need in order to make a decision on whether you qualify for the benefit that you're applying for or not. What we're seeing today in this current climate is that when you make mistakes on your application, USCIS is making a final decision on your application. So many people are finding out that they're being denied for mistakes on their application. So for example, I had a call for a consultation where an individual was filing an adjustment of status for their spouse and had to submit the affidavit of support with financial information, and a mistake was made. And instead of receiving a request for evidence, they were outright denied the application. Now, what we're also seeing happening under this administration is that when a person gets denied, they are automatically issuing notice to appear in immigration court. Now, what is a notice to appear in immigration court? Sometimes we'll call it, you'll hear it abbreviated as an NTA. It simply means that the individual is now being referred to the immigration court so that the government can initiate removal proceedings, aka deportation. In the past, if you made mistakes in your application, you would get denied and you would have an opportunity to respond to the denial, or in a lot of cases, people would just refile the case without the mistake or refile the case with strong evidence. Now we're seeing under this climate that people are being referred directly to removal proceedings, and now they're going to have to go through their immigration process in front of a judge in immigration court. And it's a lot harder to go through your immigration benefits when you are in removal proceedings rather than if you're doing it affirmatively through USCIS. So I say this to all of you, those who are looking to apply for immigration benefits and are thinking of doing it on their own. I would rethink that, especially in this day and age. I would rethink that. I would suggest and recommend that you consult with an experienced immigration attorney when you are looking to apply for immigration benefits. Even if you feel like it's a very simple application, there are no simple applications when it comes to U.S. immigration. It is a surprisingly very technical area of law that people learn the hard way when they end up getting denied on their application. So to save yourself the headache, talk with an experienced immigration attorney, have your case reviewed, have your application reviewed before you file your case.